This is Paul Turner, the Immigration Browser at Imperium Chambers. I hope the new microphone's working well and you are well yourselves. Please subscribe to my channel and hit the notification button to keep up to date with all the immigration news. Today I'm going to be talking about the latest Home Office update on the coronavirus concessions. The latest were announced on the 1st of September 2021 and they replaced the earlier guidance. This is an important update as the Home Office are reducing the concessions that are available and making it harder for people to remain in the United Kingdom or to stay in the United Kingdom lawfully as we come to the end of the pandemic. So if you really want to stay in the United Kingdom, you either need to make an application for leave to remain, or alternatively you need to apply for what's called exceptional assurance. More on that later. Or alternatively you will become an overstayer and subject to the hostile environment, which could lead to you being arrested, it could lead you to being detained and could really ruin your life. So it's vital that you do something about it. If you're so here are some of the latest concessions and I'll start with the good points. If you're applying for leave to enter the United Kingdom or remain on the basis of family or private life, if you've been unable to travel back to the UK due to coronavirus travel restrictions and your leave expired between the 1st of March 2020 and the 19th of July 2021, a short break of up to 6 months in continuous residence will be overlooked and you will face no future adverse immigration consequences as a result. In shorthand, that means if COVID stopped you from being in the United Kingdom and you haven't had leave, that's not going to break your 10 years lawful residence. It's an important point. However, you are expected to make your next application as soon as you possibly can when you return to the United Kingdom. Those who have returned to the United Kingdom and did not make a valid application to stay upon re-entry are expected to make arrangements to leave. This is the sting in the tail. If you're here with 6 months leave as a fiancé or a proposed civil partner, the current family immigration rules allow you to apply for an extension of leave if there is a good reason for your wedding or civil partnership for not taking place during the initial 6 months grant of leave. Happily, and perhaps surprisingly, the Home Office consider cancellation of a wedding or a civil partnership ceremony due to COVID-19 will be considered a good reason for you to be allowed to remain in the United Kingdom. So that's a welcome concession to individuals that just couldn't get married due to the pandemic. Now, turning to people that are looking to applications for leave to remain as a family member, and obviously one of the requirements is the financial requirement. If you've suffered a loss of income due to the coronavirus up to the 31st of October 2021, the Home Office will consider employment income for the period immediately before the loss of income, provided of course that you meet the minimum income requirement for 6 months before the date the income was lost. So if you were put on furlough, you lost your job or what have you, then they will look back to the position you were before, as long as you obviously meet the requirements. Also, talking about furlough, if you've been furloughed, the Home Office won't take account of the 80% that you've been furloughed or whatever percentage you've been furloughed on. They will take into account the 100% of your salary. So that's positive. Turning to the self-employed, a loss of annual income between March 2020 and October 2021 will usually be disregarded, along with the impact on employment income for the same period for future applications. So that's a concession both to the employed and to the self-employed. Also, and this is very important, if you're unable to provide specified documents, in some cases they will decide your application without seeing certain specified documents if you cannot get them due to the coronavirus. Otherwise, you may alternatively be asked to submit the specified documents in the future. This is really important because the Home Office tend to stick to if you don't supply the specified documents, we will refuse you and the rules are the rules are the rules. So that's an important concession. Also, if you're asked to take an English language test as part of your application, you can apply for exemption if the test centre was closed or you couldn't travel to it due to the coronavirus pandemic when you applied for your application. There is some good news for overstayers which makes a change. If your visa or leave expired between the 24th of January 2020 and 31st of August 2020, there will be no future adverse immigration consequences if you didn't make an application to regularise your stay during this period. Again, this could count towards your indefinite leave to remain if you further get leave. Child students or adult students who have made an application to study can start their studies even whilst the decision has not yet been made. Obviously, if it's against you, then you'll have to stop studying, but it's an important concession. If you've applied for, and this is really important, a health and care worker visa, and you're waiting for a decision on your application, again, you can start work. As long as obviously the application is valid and the sponsor has a license, then you can get on and you can start your job. However, if it's not approved, you'll have to stop. But it's, again, a good help for those in the healthcare sector, not surprising due to the pandemic. Now, however, if you've not applied to regularise your stay or submitted an exception assurance, you must make arrangements to leave the United Kingdom, which brings me to the bad news. The other side of the coin is that if you do not have any outstanding application, the Home Office expects you to take all reasonable steps to leave the United Kingdom where it is possible to do so, or to apply to regularise your status in the UK. So if you intend to stay, you must apply soon. However, if you intend to leave the UK or return to a country currently listed amber or red, but not have been able to do so, and you have a visa, leave or exception assurance that expires before 2021, you may request a more exceptional assurance, a further period of stay. There may also be exceptional cases where you cannot return to a country or territory which is on the green list, where that nation has perhaps closed their borders or where quarantine facilities are temporary, oversubscribed, in which case you may also request exceptional assurance. What is exceptional assurance? Well, it's not leave, but it means you can stay in the country lawfully. However, applying for exceptional assurance requires making an application and providing evidence. I can help. It can be done properly, it needs to be done properly, it needs to be supported by evidence. Also, if you were granted one period of exception assurance for a certain period of time, you must apply for a new one, otherwise you will become an overstayer. So exception assurance is a strange thing, but you can get it, but it needs to be done properly. It also appears that Tier 2 applicants now must wait for a decision on their application before starting work. Unless they're healthcare workers, whereas before they could actually start work whilst they were waiting for the application to be decided. For NHS workers, there is good and bad news. You can do extra hours, you can work in other jobs, but the end of the free visa extension for you and your family is now in sight. This concession ends on the 30th of September 2021. This is a snapshot of the changes the government has brought into place. As you can see, they are really cutting down on the number of concessions and generally trying to get people to leave the United Kingdom as far as is possible. It is therefore vital that if you want to stay in the United Kingdom, you should make an application for leave to remain or make an application for exception assurance as soon as you can. I cannot emphasise it enough. If you do not make such an application, you will become an overstayer, you will be subject to the hostile environment, and you will be liable for arrest, removal from the United Kingdom. And as you'll see from yesterday's video, the Home Office has doubled the amount of people that it's removed, albeit that it's a tiny number, but they have actually spent a lot of money on trying to remove people. And it's quite clear with this Secretary of State that removal is the main goal. So I hope I've given a reasonably coherent view of the recent changes. As I've mentioned, if you want any particular advice, please get in touch with me. I'll do my best to help you. Please stay safe in these dangerous times. I wish you and your family well. Thank you very much for watching. This is Paul Turner, the Immigration Barrister at Imperium Chambers.